So what happens if you refuse a breath test during a DWI stop? Well, first off, you could be asked to submit to a portable breath test on the side of the road before you're even arrested. Now, portable breath tests are wildly inaccurate, and they're subject to so many things that can make them completely wrong, but the result is also not admissible in court. So you could submit to a portable breath test on the side of the road, or you could refuse it. If you refuse it, it's likely that the officer is going to continue investigating you. But the one that really counts is the breath test that they ask you to submit to after you've been placed under arrest. So they take you to the police department. They ask you to blow into this instrument. If you refuse that, then they'll go ahead and charge you with DWI. But guess what? If you take the test and you pass it, they're still going to charge you with DWI. So it's best to refuse the breath test. Yes, you might have your license suspended for refusing, but you can have your license suspended for failing the breath test also. And either way, you have a right to a hearing, which could be one to keep you from having to have your license suspended. You can be charged with a DWI even without a breath test. So then the officer is just going to claim that based on their experience and training that their observations show that you did not have the normal use of mental or physical faculties. So that's how they'll charge you with DWI. It doesn't matter, they don't have to have a breath test or a blood test or any number of 0.08 or greater. They'll just claim that based on their observations that you did not have the normal use of mental or physical faculties, and they'll claim that they smelled alcohol or that you admitted having a drink. And so, yes, you'll still get charged with DWI even if they don't have a breath test or a blood test. An ALR hearing, that stands for Administrative License Revocation, is a hearing regarding whether or not your license will be suspended. So anytime a person gets arrested for DWI and they either fail a test, breath or blood, or they refuse a requested test, breath or blood, their license can be suspended. But that suspension does not go into effect for 40 days after the arrest. And you have a right to a hearing, the Administrative License Revocation hearing, regarding whether or not your license will be suspended. Now, that hearing has to be demanded within 15 days of your arrest, or you lose out on the right to have that hearing. Now, once you demand that hearing, or your attorney demands that hearing for you, then that keeps the suspension of your license from going into effect. So even after 40 days from the arrest, your license is still good. You're still okay to drive. You'll usually be given what's called a temporary driving permit. And on that permit, about halfway down inside a rectangular box, it says, if you request a hearing, this permit will remain in effect until the administrative law judge makes a final decision in your case. So that's how you know that you're okay to continue driving. So we're able to win a lot of those hearings, and those hearings can take up to 4 months or more before we have them. But we're able to win a lot of those hearings so that you don't go through a suspension of your license or have to pay the $125 reinstatement fee. But more importantly, we can use that hearing as a chance to cross-examine the arresting officer at a time when that officer has not been coached by the prosecutor, so that we can pin the officer down on issues that might allow us to win your case. These officers have a lot of misconceptions about the law. They make a lot of mistakes, and they'll readily admit these mistakes at that hearing. And that's important because later at the DWI trial, where the judge has the ability to rule that the police acted illegally or rule that evidence can't be used against you or basically throw the case out, at that trial, the prosecutor will meet with the officer, and the smart prosecutor sees what those issues are that might help you and may coach the officer, saying something like, well, Officer Smith, are you sure before you had John get out of the car you didn't have some additional facts, and kind of give a wink and a nod. And the officer may realize that they need to start embellishing or adding some things or correcting their mistakes or even lying. But if they do that, we can impeach the officer. That is, we can show the officer testified differently at the previous hearing because we'll have a written transcript of their sworn testimony. That's the way we win a lot of these cases, and that's one of the best ways to win these cases. But surprisingly, a lot of attorneys will tell you that they don't handle that hearing, or that it's a waste of time, or that it can't be won. And that's bad advice, and that's a bad attorney for a DWI case, because they obviously don't know the best way to win these cases, or worse, they don't care. That's why we include handling that hearing as part of our DWI representation at no additional cost. When you refuse a breath or blood test, that actually can make your case better to defend, because now the government is not going to have this number that they claim is accurate, although we can probably show that it's not accurate, and there's a lot of mistakes in breath and blood testing. But yes, your case is stronger to defend without that. Now, the prosecutor always likes to claim that, well, they refused because they knew they were guilty. Well, we can handle that argument, and that's not a problem. And we can show that our client refused because they shouldn't have been arrested in the first place. You see, the officer has the right to request a test, but if they don't have probable cause to arrest you, then they don't have a right to request that test. So it's always best to refuse the test. What happens is they're probably going to try to get a warrant for your to draw your blood, but they have to submit an affidavit which sets out probable cause within the four corners of that affidavit for a reviewing magistrate to look at and to issue the warrant to draw your blood. But they make a lot of mistakes in those affidavits. You know how they do a lot of cutting and pasting? You know, they just pull up the last one they had on their computer. They change a couple of names here and there. They change a couple of facts, and then they print it out, and there's their affidavit. Well, you know, they make a lot of mistakes when they do that, and a lot of times they don't set out probable cause. So a lot of times we can get the judge to rule that blood was illegally drawn, that warrant should not have been issued, so the result doesn't get admitted into evidence or used against our client. So if you refuse a test and you're facing a DWI charge, you know who to call, the Medlin Law Firm.